Welcome everybody to our panel on international law, peace and security. International law, peace, security, and democracy in Latin America. We are coming to grips with the Russian invasion of Ukraine, and it seemed to us timely to examine how matters of peace and security are playing out in other regions of the world. This panel is going to focus on the role of international law in the realm of peace, security, democracy from a Latin American perspective. So topics within this broader theme that we'll be touching on include the role of the International Criminal Court in Latin America, Latin American contributions to the law of peace with special attention to the Colombian peace process, democratic backsliding in international law, and Chile's constituent process and international law. This panel, it's part of the Global Engagement series, an ASIL series presented in cooperation with leading regional societies of international law. This one is co-sponsored by the Latin American Society of International Law, or SLADI, which unites scholars and practitioners across Latin America. We're going to go in alphabetical order today, and each of our 4 speakers will speak for roughly 8 minutes, and this will give us time for Q&A. So if you have questions, please put them into the chat, and we will try to get to them towards the end of the session. So we'll begin today. I'll introduce myself. I'm Alexandra Huneeus. I'm a professor of law at the University of Wisconsin and director of the Global Legal Studies program here. And our first speaker is Alberto do Amaral of the University of Sao Paulo Faculty of Law. So Alberto, you have the floor.
Many thanks, Alexandra, dear colleagues. First of all, SLADI embodies its gratitude for organizing jointly with American Association of International Law panel. To begin with, I will divide my explanation into different parts. The first part, I will talk about the role of Latin America. It's discussable whether or not there is Latin American international law, but Latin American countries have given an expressive and stunning contribution to general international law, undeniably. In the second part, I will try to ascertain the role of Ukraine in war for Latin America and for international peace and security, and how much this affects our current world and our developing countries. I talk in my personal name and not in the name as the Latin American Society and in the name of Latin American Society of International Law as a director of this entity. Latin American countries throughout time has contributed to international law. And one of the main functions of international law is precisely to enact standards, rules to regulate the coexistence of sovereignty unities. And the problem of international law of coexistence is coincidental, is somewhat that dates back to the emergence of modern concert of states. And in doing so, the problem of the regulation of force arises as one of the major questions in international law. And in doing so, Latin American countries have given a stunning contribution. In the 19th century, for example, the Calvo doctrine, the Tragos doctrine were illustrative of this fact. The Calvo doctrine in respect of the international law of investments and try to prevent that the use of force could serve as an instrument to force Latin American countries to repay their public debts. In the same line, the former Argentine Minister of Foreign Affairs, Luis Maria Drago, in 1902, protested against the bombing of the Venezuelan coast by great powers. And those initiatives aimed to avoid the use of force in case of public debts by developing countries, and more specifically by Latin American countries. During the 20th century, I can quote the case of Estrada's doctrine when Mexico declared neutral as regards the Central American dictatorships, alleging as a reason the protection of sovereignty. And I underline the fact that Latin American countries have throughout time struggled for the prevalence of sovereignty in international law. During the San Francisco Conference, Latin American countries ardently defended the principle of non-intervention. And we all know today that this principle has become relative due to the emergence of the responsibility to protect in international law. And another important contribution given by Latin American countries is the Brazilian legacy. The Brazilian legacy for international law is the peaceful dispute settlement. Brazil resolved our neighboring conflicts peacefully, and this gave Brazil credentials to fight for peace at the international level. And I can quote also the tradition of diplomatic asylum developed in Latin American countries, the only region of the globe that sought to put in place this tradition. But more recently, the period after the military dictatorships in Latin America in the 60s, 70s, and 80s, the reform of the OAS Charter and the inclusion in the OAS Charter of a provision according to which the representative democracy is one of the pillars of this organization, allowed to suspend Venezuela from that organization and establish that democracy should be guided among Latin American countries. And this links democracy, peace, and security. Democracy is a procedure. Democracy is a set of rules to protect fundamental rights, rights and freedoms without which you can not have the peaceful solution of disputes, and you cannot have the necessary security for a civilized coexistence within countries and among countries. And I quote in this line, the important attitude taken by the Inter-American Court of Human Rights, together with the OAS, the Inter-American Court of Human Rights, decided that self-amnesty declared and enacted by dictatorships in Latin America and the newly democratic systems in Latin America, and try not to sue crimes against humanity against the American Convention on Human Rights. And
Alberto, I'm sorry to let you know, you asked me to let you know that we are at 8 minutes.
Let me only to conclude by quoting that the Ukraine war, again, turn back to this subject, is against international law. It is contrary to Article 2.4 of the United Nations. It is a calamitous event for international relations. It harms developing countries, in particular Latin American countries, and it takes to a risk to international peace and security. It puts international peace and security in jeopardy. And this places the problem, it is emphasized the problem of abuse of power and abuse of impotence. And Latin American countries are against the great discrepancy of power at international level, and it demands a new regulation of international law, a new regulation of multilateralism, and mainly the new regulation of the use of force through an UN reform. Basically, the UN Security Council reform, the UN General Assembly reform, with a view to giving more power, more competence to this organization. Thank you.
Thank you very much, Dr. Amada Jr. Our next speaker is Jorge Contese, professor at Rutgers Law School, and he will be touching on the Chilean constituent process and the relationship of the future constitution of Chile to international law.
Thank you, Alex, and thank you to the panelists for being here today, and to the audience. I'm going to refer, as Alex mentioned, to the Chilean process that is undergoing right now. It is scheduled to finish with a proposed draft of a constitutional text in July of this year. And I'd like to just mention briefly 4 things that I think are important to consider when we think about international law and the role of international law in a domestic constituent process. The first one is that this is perhaps one of the most salient features of the rule of law, which is the theme of our panel today, in the sense that when a political community is engaged in drafting and redrafting and rethinking and reimagining its way of living together in a political sense, which is probably the best way, the most salient way, as I say, to do this, is by, of course, enacting a constitution, a new constitution, which is exactly what is happening. So my first contention here is that in the context of assessing the rule of law in the region, we have here one interesting example of a political community that has decided to reimagine its norms, to redraft, to reenact the ways in which we live together. And so that, to me, is probably the most radical and fundamental exercise of thinking and rethinking what the rule of law should entail in a given context. Of course, in a domestic context, but as I'm going to say now, heavily influenced and shaped to some extent by international law. Second, I should mention that the birth of this constituent process is directly linked to issues of insecurity, in the sense that there are 2 ways to think about this. One is the sense of insecurity that some social studies have documented that Chilean society, particularly the have-nots, have been experiencing for a number of years now, for decades. And so to understand how is it that the good student of the domestic class of Latin America suddenly was witnessing subway stations being inflamed and street violence throughout the country, it's I think important to consider how those episodes of October of 2019 through, I would say, November 2019, of violence in the streets, of police crackdown, the sense of insecurity that somehow and in an abrupt way became prevalent in Chilean society is related to a constitutional system that is not able to provide security. Security in the sense, for example, as I'm thinking of FDR's Four Freedoms, the idea that people should be free from fear if someone falls sick, that there will be a system that will provide support. If someone wants to educate their children, that they do not have to necessarily have money so that they can afford a proper, decent, and good education, and the same with social security. Those themes became prevalent as, again, a sense of insecurity in how suddenly the peaceful scenario former President Piñera, a week before the social awakening, was talking about the oasis that Chile was. And suddenly a week or 2 weeks later, the country was literally on fire. And so how do we think about going from that sense of peace that was probably not entirely real to a sense of insecurity that is channeled through a constituent process, which is what I'm going to be talking about now, more specifically, how that process came about, and particularly the role of international law. So one of the features of this process, of course, for anyone, we are talking about international law, but here in Latin America, when we talk about international law, particularly when we talk about international human rights law, there's also a continuum with domestic constitutional law. National constitution across the region, in Argentina, in Brazil, in Colombia, in Peru, in Ecuador, everywhere have a very strong understanding of the domestic constitutional law, the constitutional architecture relation to international law, right? We come from a monist tradition, unlike common law countries, which come from dualist tradition of international law. And so thinking about a constituent process in the context of Latin American politics is, in my view, heavily linked, inherently linked maybe, to an understanding of international law, particularly of international human rights law. So in the context of this particular process, what's happened is that when Congress passed a constitutional reform that enabled the constituent itinerary, among the many provisions that Congress set for the future Constituent Assembly was one in which it established that the Assembly would have to respect certain things, certain basic things. Some people call this the limits provision. And one of the things was the democratic form of government, that the Assembly should respect judicial decisions, and among other things, international treaties that are binding upon the country. And so this provision that somehow the Congress acting as constituent power enables a constituent process for a future assembly that was established in July of 2021, and tells that assembly, make sure that you respect international law, particularly international treaties. That's what the provision says. And it makes no distinction. It doesn't say, as the text of the Constitution doesn't refer, for example, to international human rights treaties. It says international treaties in general without distinction. And we know that if, in this case, the Constitution makes no distinction, it is not proper for the interpreter to make a distinction here. And so some discussion that has accompanied the process concerns what's the scope of the limitations that international law may impose on the sovereign powers of a constituent assembly. And some people believe that this basically means that the Constituent Assembly may not do anything that would put Chile against its international obligations. Some people believe that the Constituent Assembly is sovereign, and therefore it could do so, but it would have to face whatever consequences if there is an international wrong, some international wrong act in the future. And so in the last 30 seconds that I have, what I want to just put here on the table is how this conversation about a constituent process that starts with some limitations that are not enforceable in any case, what is the meaning of international law sort of governing or attempting to govern at least part of the constituent deliberations that are taking place right now in Chile. And what we will see, and this is my final comment, is not just how the convention has responded to those limitations. We haven't really seen any major discrepancies or debates along these lines, but certainly how the convention will eventually establish what the role of international law is subsequently. That is, how is it that Congress and other constituted powers will have to engage with international law? Thank you.
Thank you, Jorge, and thank you for keeping time so closely. Our next speaker is Judge Silvia Fernandez de Gurmende of the International Criminal Court, who will be speaking about the situation of Colombia, the preliminary examination of the ICC in Colombia, and the jurisdiction of the peace.
Sorry, good morning, good afternoon. I'm really very pleased to address here the role of the ICC in Latin America. This is a long and important chapter for the court and for the rule of law in a region. So it's not so easy to address it in only 8 minutes, but I promise I will do it by focusing only in two prevalent aspects of the relationship between a region and the court, including in the situations you have mentioned. Now, the first aspect is the broad support for the region for the creation of the court and its activities today. The second aspect is, and it's not contradictory, but it's somehow in tension, is the reaffirmation of national sovereignty and of domestic jurisdiction for international crimes. So this reaffirmation has in turn two elements. One is the emphasis on non-retroactive application of the Rome Statute to past abuses in a region. And second, the emphasis of a region on the principle of complementarity. Now, let's go for the first one, the support. Almost, and this is just a fact, the entire Latin American region is part of the ICC system today. Only 3 countries in Latin America, Haiti, Cuba, and Nicaragua, have not yet joined. And if we also count the entire GRULAC, that is the entire Latin America and Caribbean countries, we should add 2 more, Bahamas and Jamaica, who have not joined yet. So 28 out of the 33 countries of the GRULAC region are parties to the Rome Statute. So the Latin America and the Caribbean countries constitute the second largest group after Africa in the ICC system. El Salvador was the latest country to join from a region in 2016. So this is quite impressive, I would say. Now, but as I said, the support for the international jurisdiction has been accompanied by an emphasis on national sovereignty and national jurisdiction. First, at the time of the negotiations of the Rome Statute, several of our countries were still dealing with legacies of abuses from military dictatorships. Through accountability efforts like Argentina at the time, and also today, but also through amnesties, pardons, or simply inaction. So in this context, there was support for the creation of the court, but also apprehension that the court could step into our own national processes. So after the creation of the court in 1998, it was clear that this apprehension could jeopardize ratifications in the region. So the principle of non-retroactivity as enshrined in the statute was not sufficient to appease concerns. Why? How to interpret non-retroactivity with respect to continuing or permanent crimes, such as enforced disappearances, which were the landmark, I would say, of the abuses in the region. Remember that for these continuing offenses, including specifically enforced disappearances, the Inter-American Court of Human Rights had expressed the view that no statute of limitations apply to these offenses and that the state is under the obligation to investigate until the whereabouts of the victims are established, because the crime is extended over the entire period of disappearance. So as the problem risked to act as a bar against ratification, there was the need to clarify the matter. And the matter was clarified, although not many know about it. It was clarified in the elements of crimes, which is a complementary instrument to the Rome Statute. The elements of crimes is an instrument that clarifies what is required in a conduct to qualify as a certain crime within the jurisdiction of the court. With respect to enforced disappearance as a crime against humanity, the elements stipulate that the conduct must be committed as part of a widespread or systematic attack directed against the civilian population. So a small footnote, footnote 24 to the elements of crime, clarify that this crime, enforced disappearances, falls under the jurisdiction of the court only if such attack occurs after the entry into force of the statute. So this was the way of making sure that it was not just a crime, but the context that had to occur after the entry into force of the statute. And this small footnote turns and allowed for all these ratifications to happen. Now, up to today, there is a second aspect which I will address very briefly in the few minutes that I have, I think two. This is the emphasis on the principle of complementarity. The region supports the court, but has always emphasized that the court is complementary to national jurisdiction, has only a backup role. So efforts to ensure accountability at the national level continue to be hugely important until today. One extremely important example is Colombia, where the ICC prosecutors conducted a preliminary examination for 17 years. This is an extraordinary example of national efforts deployed as a part of a peace process conducted under the umbrella of the Rome Statute, and indeed the surveillance of the court. I trust that Julietta will tell us more about the special jurisdiction for peace that was part of the agreement on the victims of a 50 years armed conflict. The aim of the preliminary examination by the prosecutor was indeed to push for accountability at the national level and indeed determine at some point whether to defer to national proceedings. The new prosecutor has now closed the preliminary examination and signed a cooperation agreement with Colombia aimed at safeguarding the progress made under the special jurisdiction. If the Colombian government violates the agreement, it could lead the ICC prosecutor to reconsider the decision to close the preliminary examination and to seek to open an investigation. And 30 seconds to mention another important recent decision by the new prosecutor for our region, which is his decision to open an investigation in Venezuela. In this case, the prosecutor has decided not to defer to national proceedings, and the investigation is now underway. However, the prosecutor has emphasized that the investigation is not a one-way road, but only the start of a process. In parallel with investigations, he has indicated that his office will support any meaningful effort undertaken by the Venezuelan government to reform and revitalize the justice and penal system in order to enable genuine accountability. He has underscored that the principle of complementarity is the foundation, indeed, of the Rome Statute system. And I will stop here. Thank you very much.
Thank you, Judge Fernandez. Our next speaker is Judge Julietta Lemitre from the Special Jurisdiction for the Peace in Colombia. And she will be speaking about the Special Jurisdiction for the Peace in Colombia.
Hi, Alexandra. Thank you so much to all of you for having me here today. I'm very happy to be here. As Alexandra asked in her email, I'm going to try to tie in the previous presentations around the issue of peace in Colombia in a way. And I don't know if I'll be able to, but I'm going to try. So I was thinking as I heard Alberto of the regulation of force as a major question in international law and the specificity of Latin America in the formation of this issue, particularly around its struggles for sovereignty and for recognition as part of the international community. I was thinking of the right to peace as part of that tradition and of all the writers and thinkers concerned with the idea of peace in the region and of building what is paradoxically a continent that has probably the least amount of war between states, but is also the most violent, a continent that doesn't have a war in it. And so that's a paradox that certainly overshadows the peace process in Colombia as a peace process that's not a transition from dictatorship to democracy, but rather the aspiration of a transition from a situation of civil war or of a small war or of a low intensity conflict that has lasted over 50 years and to hopefully a situation of relative peace. And in the last year, these hopes have been rather undermined by the reconfiguration of small armies in the regions that were formerly occupied by the FARC guerrillas, which was the co-signatory with the Colombian state of this peace agreement. So we're seeing a reconfiguration of armed actors and a persistence of violence in the wake of the peace agreement, and rather a transformation of one war into the other, which again faces us with this paradox of an absence of international war, but a persistence of high degrees of violence among citizens. And how is international law sort of a reference in all this, in this peace process? Of course, there's what Jorge mentioned, that the question that underlies it, and I was thinking of the rock song, El baile de los que sobran, is the inequality of our societies and whether or not that's tied into this persistence of violence, and how the aspiration of creating a new constitution that's more egalitarian, which is the process I understand is undergoing in Chile, is also the aspiration of a more peaceful society with the idea that it will be less violent if it's more egalitarian. And then I was also thinking as I heard Jorge of the double nature of this reference to international treaties as binding on the constitution making process. Because on the one hand, there's the aspiration, of course, of human rights and equality as part of this international law that will be binding on national constitutions, and the idea of democracy as bringing a better life for everybody, and certainly keeping at bay authoritarianisms that have characterized the 20th century. But at the same time, I was also thinking of the way international law can be an obstacle to the creation of more just arrangements, or perhaps just arrangements that are more beneficial to the sovereign states that compose the region. Certainly in the negotiation of the peace agreement in Colombia, international law was perceived as a limitation to the possibility of peace negotiations, especially before the Inter-American Barrios Altos decision, when the whole system was understood as heavily limiting the possibility of amnesty to combatants. And that certainly was a threat to the possibility of signing a peace agreement, because no one's going to sign on a peace agreement after which follows only the promise of imprisonment and harsh penalties for great crimes. But another limitation was that of the ICC itself, which was perceived as underwriting the obligation to persecute grave international crimes, which brought us again to the prohibition of amnesties and the difficulty that this would create in negotiating a peace agreement. And this was pretty much the origin of a special jurisdiction for peace rather than just a truth commission. We also have a truth commission, but the special jurisdiction for peace that came out of the agreement was a response to the perception of international law as being a limitation to what could be brought into the peace agreement. And so the jurisdiction was charged with trying those most responsible of the crimes of war and crimes against humanity, both former guerrilla and members of the armed forces that committed these crimes. And it was charged with applying both domestic and international criminal law. Now, since most crimes did happen before the adoption of the Rome Statute, we have an additional conundrum. And I was happy that Judge Fernandez referred to forced disappearances, because this is certainly a cornerstone of the issue in the region of transitional justice, of the possibility of peace, and of the impact that forced disappearances had in our society, and the right to truth that emerged from the judicialization of forced disappearances. So this is an enormous importance of our countries. And as Judge Fernandez mentioned, the Rome Statute would not apply in the sense that it limits the jurisdiction of the court to crimes that committed long after the heyday of forced disappearances. So in a region. So one thing that we have grappled with is whether or not we can talk about a jus cogens of a prohibition of forced disappearances, or if we could talk about it as a matter of regional customary law or not, the rejection of disappearances beyond murder, the non-accountability for people that were taken by both the guerrillas and the army, and the denial of information to their families about their whereabouts. So all these issues are tied in the experience, in our experience in the special jurisdiction for peace of international law, both as enabling the possibility of creating a more just society and talking about the wrongs of the past, and also as a constraint in the possibilities of creating this peace that we all aspire to. That's a peace, as I said, not of war between countries, but a peace in relations to high levels of internal violence. And here again, I want to close with one idea that I find particularly troubling in relation to international law, and it's the issue of prohibition. So when Jorge talks about the international law being a limit to the possibilities of the constituent making process in Chile, I was also thinking of the 1961 convention, the prohibition on narcotics and everything that comes from it, and both all the international agencies and investment in interdiction. It's really hard to say, and I'm not a social scientist or a historian, but just a lawyer, but it's really hard to take that out of the equation of violence in Colombia. So of course it's a complex equation. There's a history of weakness in state formation. There's a complicated geography with long and porous borders, both land and sea borders, dense forest, and a lot of issues that have been brought forward as being part of the cause of this persistent violence. But I have to say that international prohibition is certainly part of the equation. And for Americans, I think that a clear reference would be the impact of the Homestead Act in the US in the 20th century, when the prohibition of alcohol, a commodity which, like cocaine, has an enormous domestic demand and was a very profitable business. In those brief years of prohibition in the United States, it weakened democracy. It faced the federal government and local government with the impossible challenge of interdiction, with civil disobedience to interdiction, with the way prohibition of a substance for which there's such a vigorous market ends up empowering criminal outfits. And I don't mean just empowering them because it makes them rich, but because every market requires a non-state, it requires a regulator. And when the state renounces both the possibility of regulating the market and of taxing it, then criminal outfits step in to do both. And it makes them more powerful and generates corruption as well, especially corruption of those government agencies that are charged with enforcing interdiction, which is usually police officials, but it's even more dangerous in a region when the armed forces are tasked with interdiction of drug trafficking. Because of the dangers that we have all seen in practice of prohibition of the corruption of these forces. And this context is not a natural situation, as one might say, of the geography itself of Colombia. And it's not a long historical problem like weak state formation, but it's directly created by international law. Thanks. Done.
Thank you, Julietta, for that. I really appreciate that you began to weave together some of the presentations before and comment on the transversal themes and the shared problems and challenges and the meaning of international law across those problems and challenges in the region. We now have 18 minutes left in which we can have a conversation, we can ask each other questions, and we can also take questions from the audience. So if anyone would like to pose a question, please feel free to do so. I'll start us off. I am struck, there's a way in which, as I was thinking about this panel, there are certain things that give hope. Julietta has given us, some reasons, focus on some of the challenges, but the constituent process in Chile in particular is one that channels political discontent and years of frustration into a democratic and institutionalized process of political renewal. And of course, there's scary moments, there's a lot of risk involved, and yet it stands in contrast to so much that's going on in the world, in particular turned to populism and authoritarianism, which is happening in other places. And the new government of Chile, a product of this political renewal, is emphasizing human rights law in its foreign diplomacy. And for all of the challenges facing the Colombian peace process, there's also a way in which the JEP Colombia has created a transitional justice mechanism that in many ways marks a new era in peace building, to the point that the ICC closed its 17-year-long preliminary examination. So one question I have for the panel is, as the world order is rewritten, a process hastened by the war in Ukraine, is there a way in which this creates space for Latin American legal practices, for there to be greater innovation in Latin America, and for Latin American practices to have greater influence beyond Latin America, something that Alberto talked about in his talk. And then I also wonder, I was struck by Julietta's emphasis on international law, not only as enabling, but as hindering progressive change and just change. Some of the problems that are pressing are transnational problems, such as climate change, immigration, and gang violence, the transnational nature of gang violence in the region. And I'm wondering if there's a way in which international law, because of its focus, especially human rights law's focus on national jurisdictions and their control over their territory alone, whether there's a way in which this now has to be a focus of rethinking and reform in light of the types of challenges that face the region, and not just the region, the world. So those are just some general questions to throw out to the panel for your reflection. And please feel free also to comment on each other's papers and to ask each other questions. And whoever would like to
begin?
Well, we can go on the order that we have started unless someone wants to jump in or wait. Or would you like to begin, Alberto?
Yes, yes. National law and about the Ukraine war and its effect on Latin American countries. Latin American countries are developing and least developed countries. It's necessary to emphasize. And the Ukraine war brings economic inflation, the recession. It brings risks to international peace and security, and Latin American countries are alienated from a broader discussion of peace, international peace and security. It is notably the Western countries are considered to be the United States, Canada, the Western Europe, Japan and Australia, but not Latin American countries. It is a negative fact. And second, about the role played by international law as a facilitator or as placing some obstacles to domestic process. I quoted the case of self-amnesty laws passed by some countries. And in this case, the Inter-American Court of Human Rights performed an ambiguous function. I don't want to defend in every case the role played by the Inter-American Court of Human Rights, because in some cases, like in the Uruguayan case after the Angel law, there was a democratic referendum, and this democratic referendum should be respected by the Inter-American Court. The Inter-American Court did not seek a more constructive role in this case, and aimed only to be the last Supreme Court, the power, the purview that it does not have to rule what a democracy is and what a democracy is not in the continent. And my observation, my exception to the role of international law in the continent and the case of the Ukraine war, and it's legitimate that Latin American countries claim a more active process in this case and plea for a broader reform of international order in terms of international peace and security.
Thank you. Jorge, you would be next unless someone wants to jump in. We don't have to be that formal, but.
I'm happy to just make a couple of remarks here. The first one is that I think I heard you say that we are experiencing the rewriting of international law, Alex. And I'm just not sure that that's what's happening, or that might happen now that we are seeing this conflict unfold in Ukraine. I would like that I would like to see that happening, that we're moving somehow in the direction of truly revising the legal architecture that we set up 70, 80 years ago, in the aftermath of Second World War. And everyone now seems to be talking about how the UN Charter, the prohibition of the use of force is being violated, how this aggressive war is against all international legal obligations and so on. And yet the question, and I'm not saying this in a rhetoric way, I'm not sure what the direction is going to be, whether or not the international legal order will come out stronger or weaker after assuming that there's an after this conflict, right? And in relation now, bringing that conversation to the region, I would say a couple of things. One is, it's interesting that on the one hand, as Alberto was mentioning, the role of the Inter-American Court of Human Rights, it has a role that, in my view and others, it very much acts as a sort of regional constitutional court. And so once again, we see this processes of constitutional law and international law being kind of intertwined in ways that we might not see in other regions. That's, I think, a distinctive feature of Latin American law, both international law and constitutional law. And along those lines, of course, the Inter-American Court of Human Rights has sort of taken its own path in trying to shape and influence general international law. Just to give one example of what Julietta was mentioning, the norms of jus cogens, right? Whether or not there's been this expansion of jus cogens in the jurisprudence of the Inter-American Court of Human Rights, which has not had a reflection in the jurisprudence of other international tribunals, probably most saliently the International Court of Justice, where Judge Antonio Cansado Trindade, who was one of the voices pushing for this expansion of jus cogens as an Inter-American court judge, I would say has not been able to persuade his colleagues in the ICJ. So my final comment here is that, on a sort of a positive note, I think Latin American states are good at bringing their disputes to an international legal fora, right? Whether it's the ICJ, now we'll see the hearings in the Chile versus Bolivia case. There have been plenty of cases brought by Latin American countries against other Latin American countries before the ICJ, but also some other, what I call more interstate disputes in disguise. For example, the ways in which we only have two cases that are actual interstates within the Inter-American human rights system, but the ways in which Latin American states use, for example, advisory proceedings before the Inter-American Court of Human Rights can also be a way of using international law to shape law that transcends the interstate disputes and that will have effect, beyond that interstate dispute. So I would, on a positive note, I would say if there's something that we can learn from Latin American international legal experience is the will to use the international legal order to actually solve disputes, or to try to solve disputes. Maybe not actually, but to try to solve disputes. I leave it there.
Which is interesting in light of the relative dearth of interstate war in the region, like perhaps that Julietta was mentioning. I wanted to interject here. We have a question from the audience. I'd love to give that person the opportunity to ask the question, and then we can go to Judge Fernandez and Judge Lemitre and close there. So we have Hugo Relva, legal advisor for Amnesty International. I think Wes or someone has to give him the ability to speak, or otherwise, Hugo, maybe you can put your question into the chat and I can read it. Okay. Okay, so Hugo, if you can please put your question into the chat or into the Q&A, and I will ask it. And in the interim, let us go to Judge Fernandez.
Thank you. While Hugo writes his question to me, I can start with my comments on following what has been already said by my two colleagues in the panel. Now, on the Ukrainian offensive by Russia, and whether we are going into a new world order or a rewriting of international law, I think it is too early to tell. Someone said, well, what is going to happen after, if there is an after? Well, there will be an after at some point, but when and how, I think is too early to tell. I think what we are looking now is that, well, we have been surprised by a use of hard power in a way that we were not used to anymore. So in a way, it's not that we are rewriting international law, but we are going back to the basics, the fundamentals of international law, the prohibition of use of force, etc. At a time where we were looking at new issues. For instance, in the context of the ICC, we were saying, well, we need to look into the new phenomena that are important to us. And you mentioned some of these, like climate change. We were discussing whether, for instance, we should amend the statute to incorporate new crimes like ecocide, for instance. So this type of discussion on new issues was starting because we thought we were out of the old basic international law issues. Well, we are back to the basics, which doesn't mean that we will forget about the others, but right now we are back to some of the fundamental challenges of international law. So how this will happen and how this will affect our region, it is very difficult to tell at this point. So I will go into another issue, which is, well, we see how international law is being affected, how international law is being violated. And there is this issue that has been mentioned by Julietta and others, and how international law can also help promote something, but also hinder. And of course it hinders, and this is the idea. The idea is exactly to have, through international law, a certain order, certain things that need to happen in a certain way. So the idea is not so much that international law should not hinder anything, but rather to what extent this is an obstacle to something good, or it is indeed a promotion of a more sustainable order. And here I would like to actually ask a question from Julietta, who I think may come after me, is for instance, all the system of the Rome Statute indeed was an obstacle to amnesties. But actually the Rome Statute also incorporated what has already been said in other fora. And of course, later on, a few years later, we had the decision in Barrio Salto that she mentioned, that indeed put amnesties out of the question, saying that the amnesties were a violation of the Inter-American Convention of Human Rights. So my question here would be whether the Rome Statute system and these prohibitions of amnesties actually was really an obstacle or really promoted something better, like the jurisdiction for peace, and whether this is not actually, even if it was more difficult to create it or to generate it, whether at the end we could say that international law really helped here.
Thank you very much, Judge Fernandez. We now have the question. I think it ties quite directly to what you've just said, and perfectly posed for our final speaker, who's a judge in the jurisdiction for the peace. The question is, it was said that international law is an obstacle to peace. I think it is not so if peace does not provide for impunity of those responsible for crimes under international law. That is my comment. My question is that, bearing in mind the International Law Commission has concluded that the prohibition of war crimes and crimes against humanity are jus cogens norms, would the peace agreement in Colombia be in accordance with such a conclusion? So Julietta, it's 9:59. We'll go a bit over. You'll be the last speaker, and then we will close. Thank you.
Thank you. How much over? I'll try to be brief, but this is really complex.
It is. I think it's worth going over.
So the system as it is does provide for accountability for those most responsible of the gravest crimes. Either they accept the charges of having committed these crimes, and then they are diverted to sentencing, and the sentences are mostly oriented towards a limitation of liberty, but also towards what are called trabajos, which is a work that will benefit the community or have some sort of reparations to physical work. Or they don't accept the charges, and then they'll go to trial. And if they lose the trial, they'll sentence to jail time. So basically, that's the system that was built pursuant international law, both the Inter-American systems jurisprudence and the long shadow cast by the ICC. But I do think that we have to reflect, and if I'm going to put it in terms of law, on the idea of a right to peace. So when, of course, it's desirable that people who are responsible for grave crimes are accountable for those grave crimes. But this seems to be a charge that's not brought against every state in every situation. So international law, as you well know, is not, is also the province of power. And so when the United States invaded Afghanistan and Iraq, it has no legal consequence in terms of international law. And probably Russia's invasions of Ukraine will end up in a peace treaty and not have any consequences in international law in terms of charging those most responsible, even if investigations are being opened. If we are objective, there's a very slim chance that the Russian generals will be brought to justice and accountability for the crimes they are committed, or the Ukrainian army, if so. So in that context, I do think that the right to peace needs to be better articulated as a goal and a value in itself, and considered whether or not it's a majoritarian right. For example, there was a debate in Colombia on whether or not the right to peace could be subjected to a plebiscite, in the sense that it might be, by definition, a counter-majoritarian right. In the sense that even if most of the population decided to wage war, you could, in really a legal aspiration, say, no, the right to peace trumps those who want to go to war. But you understand the complexities of this all, but I do think that the right to peace needs to be brought into the discussion as such. And it's enshrined in our Constitution, and there's a lot of debate on what it means. And I do think that it does mean a limit, or at least there needs to be a ponderación, a balancing between the interest of peace and the interest of justice. And we're trying to make it work, but I will say that the work itself on the ground is very difficult.
Thank you. That was actually very succinct and powerful. And we will close now, as we've gone a little bit over. I do want to thank you all for coming today, for having this conversation. I think that we've touched on some really interesting and promising ideas and themes to keep on thinking. I'm going to listen to it again myself. And thank you for the audience. Thank you for the question. And we'll close here.
Thank you very much.